We interact with them every day, and they are a huge piece of the American business landscape, the most common form of business. We're talking about corporations, and today we will chat about what makes them unique and how they work. A corporation stands alone. It is an artificial person created through the government. It exists separate from its owners, and in the eyes of the law, it is treated like a person. It owns its own assets, exists indefinitely, takes on its own liabilities, taxes, and debts. That also means it can sue others and be sued by others. To create a corporation, an individual or other entity files articles of incorporation with the Secretary of State. Once approved, it becomes a domestic corporation in that state and will follow the corporate laws of that state. It is not limited to conducting business in the state, but if it branches out operations, it may be required to register as a foreign corporation in those other states. The articles of incorporation must contain the following: the name of the corporation, the number of shares of stock the corporation is authorized to issue, the street address of the corporation's initial registered office and the name of its initial registered agent, and the name and address of each incorporator. The incorporator is the person responsible for this filing. And the articles may contain optional provisions, such as the purpose for which the corporation is organized. However, if the articles contain no purpose clause, the corporation will automatically have the purpose of engaging in any lawful business. Also, if no reference is made to the duration of the corporation in the articles, it will automatically have a perpetual duration. The cost to file with the Secretary of State varies from state to state, and the fees range from $40 to $275 generally. A corporation is owned by shareholders, also known as stockholders. The corporation sells shares to raise funds, but control of the corporation is not held by the shareholders. Instead, the shareholders elect a board of directors at least once a year. These directors make the decisions for the corporation and often appoint officers to manage the operation of the business. Most states have laws about the professional responsibilities of corporate directors and officers. It is the bylaws which lay out the rules and regulations for the board and the officers. The bylaws are adopted by the shareholders or the directors of the corporation. In the bylaws, you'll find the rights and duties of the officers and shareholders and directors, and usually things like the fiscal year adoption, how the company may enter into contracts, transfer shares, hold meetings, pay dividends, and make amendments to corporate documents. You may think, why would I buy shares of a company and then not be able to be involved with running it? Well, the main reason is that the structure of a corporation provides a shield of protection to shareholders. They are not responsible or liable for the actions of the corporation. The law will only look to the company to pay. That's a huge consideration for an investor. So long as the investors and shareholders don't fit into one of the following situations, they should be protected. But here are some ways you could be exposed to liability as a shareholder. If there's a failure to maintain the corporate records and personal and corporate funds are commingled, the company was grossly underfunded with capital. The formation was done to evade an existing obligation or to perpetuate a fraud. Corporate assets were diverted improperly. If you are interested in starting a small, family-owned or closely held corporation, be cautious of these things, since most cases involving the loss of protection are found in these type corporations. Large or publicly traded corporations typically don't see these issues. Instead, the large corporations face tougher regulations on the sale of stock. Federal and state law cover the sale of securities to protect investors from business owners who may be less than ethical. There are procedures and rules that regulate the exchange of shares of stock. The main goal of any business is to make money, and with a corporation, any profits are its to keep. If there are enough profits, it may elect to pay shareholders some of it in the form of dividends. But some disadvantages of a corporation is that the income is taxed twice. The government will tax the income as a whole at the corporate level, and then part of what that income has been is paid in dividends, that gets taxed again for the shareholders to pay at their level. Suppose a corporation isn't successful and fails. The board of directors will meet to vote on dissolving the company, and then shareholders must approve of that action. The bylaws contain the procedures. Once that is complete, a filing of certificate of dissolution is made with the state, and if there are no pending tax issues, the state will approve it. But it's not over yet. There are formal notice requirements that need to be made to the IRS and to creditors. Typically, the company will still exist for purposes of winding down the business. After all claims are settled, any remaining assets can be distributed to shareholders, again, in accordance with the rules and the bylaws. As you can see, corporations can be complicated, but with a good plan and good management, it can be successful. Thanks for joining me.